Hi, everybody. I'm Andrew Jaloza for the Estate Planning and Elder Law Group here in Queens, New York. And I'm here with my friend Matt Deliberato. He's in Cleveland, Ohio. We're two estate planning lawyers. Can you imagine? This is going to be an estate planning lawcast where two elder law attorneys are going to share stories and share war stories and talk about how the practice appears to each of us in our city and how they're the same and how they're different. How you doing today, Matt?
I couldn't be any better, Andrew. Thank you for asking. I'm so happy to be here today. I know it's two estate planning attorneys, which sounds like a barrel full of monkeys. Is that the uh,
Well, it sounds like something like watching paint dry or something like that.
right. Yeah. That's a better analogy. I love it. I love it.
Yeah, yeah,
Well, good. We're talking
yeah.
about power of attorneys today. I'm excited. Power of attorneys are one of my favorite topics.
Yeah, a pretty important document, right?
Yes.
Yeah,
Probably,
yeah.
as you said, essential. I like that word essential. It is an
It
essential
is
document.
absolutely an essential document. And I think you had a story that you were telling me the other day about a client, a young client. Can you wanna repeat that
Oh
one?
yeah. So we had a woman come in and she said, I need a power of attorney for my 18-year-old. And I said, well, good for you. I'm so happy you want to do that. And she's like, well, it's not good for me because my daughter was in a car accident and she's okay. But we went up to the hospital and of course there was no way they could talk to me, right? They had no ability to talk. So, um, what are you going to do? That's just part of it's a world we live in with the HIPAA laws, with the privacy laws. This is something that is so imperative to us.
You mean a
That
parent can't talk? You can't get answers on
no,
behalf of their kid? How does
no,
that make
no,
any sense?
no, no,
What do you,
no,
why
right?
was that? Is
Well,
there a
so
reason?
well, all the laws that are in place, they are an adult. Once they're an adult, they can't, you can't share information. It's not, you're no longer the natural guardian of that person. They are their own person. And in fact, my wife, I was telling you earlier, my wife got an email at 12:01 a.m. saying, you're no longer on their prescription record. You're no longer on their medical record. You're no longer, it's just amazing how, um, yeah,
You turn 18 and all of a sudden the whole relationship between parent and child changes, right? Because
yeah,
at 18 you're a legal adult and there are some laws that extend that parental coverage for things, but in the case of in the case of owning things or whether someone can speak or do something on your behalf, you
right.
turn 18, you're on your own, right?
Yeah, you're on your own. You are absolutely on your own. And so it's imperative. I have all these friends that they're starting to go to college and we're saying, okay, got to do power of attorney. And they're like, why? I have no reason to do power of attorney. What are you talking about? I have an 18-year-old. It's absolutely the perfect time.
That's the reason, right? You have an
Yeah,
18-year-old
you
old.
have an
There is the
18-year-old.
reason. Yeah,
There
I
is,
mean, you'd probably be surprised to find out, besides, the 18-year-old thing and your child becoming an adult, but when you are a married couple and one of you owns a property, say a bank account in your name, something
yeah,
happens to you, and even if all the whole family's money is in there, your spouse, by law, is not going to get into that money and be able to deal with
that's
it,
right.
even to help you with it, right?
That's right. That's right. That's so true.
Yeah,
And
those.
it's so important. And what is a power of attorney, Andrew? Tell me, what is a power of attorney?
Well, there are different types.
Yeah,
We have powers of attorney that are called healthcare powers of attorney. Here in New York, the convention is we call them healthcare proxies. So that's or healthcare directive. These are advanced directives because you're creating them before you need them, so that in case something happens, then this document will be there and in place, and you can help. So there's healthcare powers of attorney, and we'll keep it simple, healthcare power of attorney. And there are durable general powers of attorney for property rights. You want to explain to them what we mean by durable in general?
yeah. So general means we cover a lot of topics. It covers anything from real estate to bank accounts to taxes to creating trust to making gifts. There's a bunch of powers in there and they have to be enumerated, right? We can't How many power of attorneys do you see, Andrew, today that you go, okay, well, we got to redo this? And they said, well, we just did it a year ago. Well, yes, but you don't have the correct powers in there. You don't have enough powers in there. You don't have enough instruction in there, right? So that's the reason. Durable means it lasts your entire lifetime, whether you're competent or incompetent. And we call these immediate power of attorneys. You have power right away, which we used to do a lot of springing. I did a lot of springing power of attorneys, and springing just meant that the power didn't become active until you became incompetent. Well, that was becoming a problem because it was hard to get a doctor to certify that. It was hard to get someone to, figure out, are they unable to handle their own affairs? And what does that mean? Does it mean paying bills? Does that mean their own health care? Does that mean, end of life issues? So it got very confusing. But durable really just means that it lasts during your incompetency.
Yes, very important. Those 2 points are very, very important. Durable, meaning that in case you become incapacitated or you become incompetent, that this document is still in effect because that's when you need it most, right? So
Right.
that's number one. And number two, general, because there are so many things that you may need help with, and some of them must be specifically enumerated. They must have that power built into them. I guess we'll go
Yes.
into that in a little bit more detail in a couple of seconds. But
Sure.
so why is it important again that as your child goes away to college? Why is it important that we need to get a power of attorney in place?
Well, I think you're begging a question. You're looking for an answer. I like that questioning. You're looking for an answer, and I'm going to give it to you.
All right.
The answer, the answer is that they're their own person, right? You should elaborate more on that than I should, Andrew,
Yeah,
right?
yeah, yeah, and that is true. You're when you have a child, you are the natural guardian of that child until they reach maturity.
Yes.
Most states, maturity is the age of 18. So at the age of 18, they are an independent person now. And as an independent person, they have the rights to privacy, as Matt pointed out, both from the health laws and also from property law, that these people are now independent human beings. Well, and
Yes.
you're no longer the guardian. You're no longer the natural guardian of your 18-year-old child.
Right.
So they go away to college. You try to find out what's going on and why Junior is getting a C minus. They're not going to talk to you. Or
No.
if they're in a health clinic and you're trying to figure out what they need and how you can help them, they're not going to talk to you either because there's no HIPAA release, that Healthcare Privacy Act that makes it so that doctors must, by law, maintain the confidentiality of their clients.
Right.
So 18 years old, good idea to, send them off with a present when they go to college. They give you a present, actually. They give you the power of attorney, right? Because a power of
Yes.
attorney is a document that someone signs. They're the principal. And then they give the person who they appoint, their agent, the power to do things, right?
Absolutely. And I would say it's so imperative, 18 to 80. It doesn't matter how old you are, you have to have a power of attorney. Because what's the option? Andrew, we know when we don't have a power of attorney, we have to go through what's called a
Guardianship. And
uh,
that's true.
another
That's
key
kind
word.
of true. That's kind
Yeah.
of true for everything in this world of estate planning, right? There's
Yeah.
two choices. There's making plans and not making plans.
Right.
You don't have to worry if you like the automatic plan that's available for you, as that's your local state rules and laws. And you can only imagine that you're not going to get a tailored plan from the laws and the rules of the state that you're living in, right, Matt?
That's so true. So true. And a guardianship is a process in probate court. And we all know when probate court's involved, it's government involvement. And I call a guardianship an RPIA. I've never told that to you, Andrew. Do you know what an RPIA
RP,
is?
no, what's an RPIA?
Royal pain in the you fill in the blank.
Ah, yes, indeed it is.
Right? And it
Yeah,
is. It is. Every penny that's spent, you have to account to the court. You can't spend money without getting permission from the court. And there's just so many rules and steps, and it's just a hassle, right? I don't know how else to explain it.
let me ask you a question. In your court system, in our court system, guardianship, the law that creates guardianship itself says this is the absolute last resort. In other
Ah,
words, you have to try to do anything other than do a guardianship. It is so intrusive. It really is a situation where a court is now issuing an order that takes away a person's rights to be themselves, to make decisions for themselves, to do anything for themselves. And in your courts, do they appoint court evaluators and court examiners who look over the shoulder of the family and to make
Oh, yeah.
sure, and who pays for all those people?
Oh, you know it. It's the family. It's not the court, right?
Right.
Definitely the
It,
family. And we don't have that in our law. We don't have anything specifically saying it's our last resort, but certainly the court is always open to mediation or anything less than a guardianship. And I get that. And that's, we try, but the guardianships I've been involved with, I know the kids will never get along again. That's most guardianships. We
yeah.
have kids who just end up, one has one idea, the other has another idea, and the court has a third idea, and nobody gets along. It's not fun. It's
Yeah,
not fun.
it's never good when the government gets involved in your intimate life.
Right.
It's always, seeking some other alternative is always best,
Right.
right?
And don't forget that public record, right? It's all public record. Everything you own is now public record. So it's something
Yes,
you definitely need to avoid. And how do we avoid it? But with a power of attorney, right? And
absolutely.
it's not guaranteed. I have people who have power of attorneys that still ended up with a guardianship because the power of attorney wasn't doing the right thing, or, for some reason or another.
Yeah,
Um,
or the power of attorney was not good enough, right? It was not
right,
done. It was not
right.
done well. It didn't provide for the powers that were needed. So that notwithstanding that you had a power of attorney created, it just wasn't effective. You couldn't use it, and you had to go get a guardianship anyway.
Yeah, that's funny because I have one now. We do qualified income trust, and that's a Medicaid issue. And so we'll get into Medicaid in another podcast, but just simply put, if you don't have a qualified income trust and you're going to go on Medicaid and your income level is above the federal poverty level, we have to do this trust. Well, in Ohio, tell me New York's different. In Ohio, you can't create a qualified income trust unless it specifically says it in the power of attorney. And so we're going to the court to get a guardianship just specifically to open a QIT or qualified income trust. And so, that's just one example of how many we could give of that one power. You're missing one power, and we're ending up in court. It
Yeah,
just it.
we have
Go ahead.
differences so we have differences obviously in Medicaid, and we'll definitely have a few episodes on that because
Yes.
there are so many different types of things that are different. But especially with this, we use what we call pooled income trusts to
Oh,
when we have over resource for income for Medicaid. So we don't need to use a qualified income trust to do that.
okay.
But yeah, I think the
Interesting.
qualified income trust is a good alternative, and the pooled income trust has its drawbacks too, but we'll talk about that at a later
Sure.
podcast. But as we said, you know what happens is people go get a power of attorney, and they go to say their attorney that did their real estate transaction, and the
Yes.
real estate attorney will often, or you go to a multi-center, or you go to the local notary guy, and they say,
Yeah.
oh yeah, we can do a power of attorney. They go
Yeah.
online, they look up power of attorney, they print out the form of power of attorney, and it's a general, durable power of attorney, but really simple, a simplified form. The state's barest essential ingredients, let's say, are in that document. It's not going to work if you have elder issues. It's not going to work if you have trust issues. It's not going to work with guardians. It's not going to stave off a guardianship. It will not do
Yeah.
that. So it's really
No.
important to know
Yeah.
that.
No. I was just going to say in Ohio, we have it in the law. The power of attorney form is part of the law. And so you can print out this Ohio power of attorney, and it is just a disservice. It does nothing. Our power of attorneys, I don't know about you, Andrew, but we're around 16, 17 pages long. And people always say, well, why do I need that? I just want a simple power of attorney. And I say, yes, but what one power in there will you need that won't be in there? Right?
Right. Not right. You're
And they
exactly
can't
right.
tell you, right? We don't have the crystal ball. I love that analogy all the time.
Hmm.
We don't know what they'll need. And so we do Medicaid planning. We need to create a trust. Well, there's no power to create a trust. Sorry, we can't help you.
Exactly. Or fund a
So,
trust, right?
Yeah. Well,
You have to
yeah.
put you have to set money aside into a trust in order to qualify for things
Yeah.
like that, or the power to deal appropriately with the real estate or the taxes or the deal with
Right.
the government
Right.
agencies. It's
Right.
important to have a very broad and general power of attorney, especially as we get older, right? Dealing with an 18-year-old, it's not
Yeah.
the worst thing in the world. You have a simple, direct power of attorney, and that's great. I think that
Right.
I think that's a good point, right? Don't you find that everything, while it may be a power of attorney, like you said, 18 to 80 is something that everybody needs one. But don't you think that there are differences what you need at different times of your life?
Yeah, I agree. Absolutely. I think the younger you are, probably the more simple your life is, the more simple the power of attorney can become. Absolutely. But I think that the expanded power of attorney will last them forever. How many 18-year-olds do we have today who will be 80 and still have that
Right.
power of attorney?
And probably never go back to another person because I have this power of attorney, right?
Right, right.
Yeah, that's
Exactly.
true too. Once you get it done, you kind of feel good about having it done, and then you figure you never need to do it again.
Yeah.
So when's the last time the power of attorneys, the law that generates power of attorneys in Ohio, when's the last time that they changed that form in your state?
2013. That's how
Oh,
old
well,
the power of
okay.
attorney is. Yeah. So that we're sitting with a document that probably doesn't work for the 2020s, right? It just
Yeah,
doesn't
maybe.
work. How
Yeah,
about you?
well, so in 2010
Yeah.
was the first time the power of attorney had been changed, and it's got to be like 50 years, right? 50 years before that, the last power of attorney, and
Yeah.
basically it was a simple basic form
Right.
until I don't know if you know the name Brooke Astor and the Astor family. Well,
Yeah.
Brooke Astor was a socialite, one of those like industrialist families that had
Yeah.
hundreds of millions of dollars. And so she had this power of attorney, the short form power of attorney that the state had, and her son was her power of attorney. Basically said, "My son can do anything he needs to do to help me." That was simple as that. And he
Yeah.
did. He helped. He helped himself to all of her
Oh,
$100 million, along
nice.
with his attorney who helped him. And
Oh,
so
sure.
at that point, 2009, 2010, for the first time in over 50 years, the New York power of attorney changed. And then
Oh my
it
gosh.
limited the gifts that an agent can get, and an agent has to actually sign the power of attorney here now in New York. And
Wow.
then last year, 2021, it changed again to increase the amount that an agent can get because it was so limited. They limited it to $500 per year. Can you
Oh
imagine
my gosh.
trying to
Yeah.
help your principal and only
Yeah.
can transfer $500 a year? So
Oh my gosh.
they've expanded that, and they've expanded the gifting powers to enable an agent to actually do Medicaid planning for
Oh,
someone who
good.
needs it. Yeah.
Yeah, we
So
have
now
not gotten there yet.
yeah. So, and when you have an outdated power of attorney, it kind of creates a problem in some areas too, because
Absolutely.
you go to use this power of attorney, and it's on the expired form, and
Yeah.
it may not be, the people who need to rely on it may not be willing to recognize that power of attorney.
No, and that leads me to what we believe is documents do not work, plans do. Planning not only means creating it, it means integrating it with your life and what? Maintaining it. We have to
Yes,
maintain things. Without all three,
absolutely.
it doesn't work. It doesn't work.
Well, it
So
works
yeah,
when you get it. It works when you
well,
get
yeah,
it. It may
right,
not
right,
work
right.
when you need it.
Right. You imagine walking into a bank with a 10-year-old power of attorney and they're going, is this person still alive? Do they want you as power of attorney? Is this thing
Right.
still valid? We have to maintain. Maintenance is
Well,
so
most of
important.
the time when you walk into the bank, what they tell you is this form is not on their form, and
Yes.
they don't want to let you use it. We
Yes.
had some changes with that too here in New York, and then the recent change added into the law is the banks no longer have just blanket right to deny you using your power of attorney. That you went
Oh,
to a
good.
lawyer who you paid good money for, who's an expert in the law to create the power of attorney. So now, if the banks insist and there's a harm that gets caused because of that insistence for no good reason, they have to pay triple damages.
Wow.
Yeah,
Wow.
some teeth in the law. Some teeth.
Yeah.
Yeah.
That's great. I wish that was here because we have one bank that says If it's not our power of attorney, we won't accept it. And I said, well, how do you take this woman who's in a nursing home with dementia and create your own power of attorney?
Yeah.
It's just, it can't happen. It doesn't work. It doesn't work.
No,
So
not at all.
that's good to
So
know. That's good to know.
so how important is it? So we have this document. It's a power of attorney. You appoint someone to go do something for you when you can't.
Yes.
How important is it to choose wisely who you name as your agent?
You know, I had a woman come into me once, and was with her niece, and the niece said, "My aunt wants to revoke her power of attorney." I said, "Okay, we can do that." And I started asking some questions, and the niece kept elbowing the aunt, saying, "Go ahead, tell him, no, quiet, no, quiet, tell him," back and forth. So now I had to know, right? Like, what is going on here? Well, apparently the niece's brother, so the nephew, had a power of attorney made by an attorney friend of his and took every penny she had.
Hmm,
And I said, well, we should probably pursue him. And he said, oh, he didn't mean to do that. Now,
sure.
she still talks to him. He built a beautiful home in Florida with her money and everything else. So how important is it? It's so important. But here's a nephew who you think you can trust, right? So I I don't even know how to select. You have to select out of gut instinct, right? You have to feel good about that person, their morals, and what their life path has been. And I think that's the best way to select them.
Yeah, absolutely. Choosing absolutely very wisely. But even so, as you just pointed out, she really loved and trusted this nephew. Sometimes it's also good to have some safeguards in that power of attorney. Like if
Yes,
you have a power, you have an agent, and it says that, you need to look at what other estate planning documents this person has, the principal has, before you
yes,
allow this person to take all the bank money out of the bank. That will
yes.
make it so that they can't really do that, right?
Right,
A
right.
little bit, because don't you think that a power of attorney broadly written without any kind of controls is just a blank check,
Absolutely. A blank
right?
check that's exactly what it is. And then you see these, what do we call them? Super blank checks where they have every power in there. And then
Right.
yeah, yeah. No, I'm with you. Yeah.
So, so it's really important to choose wisely. It's important to have some safeguards built into your power of attorney. And you're not going to get one of those if you go to the divorce attorney generally or to the
Right.
real estate attorney to get your power of attorney prepared, right? As how it will affect your estate planning and the things that you have, your wishes of who's going to get what, when, and how.
Absolutely. One last topic before we wrap up, Andrew, is that capacity is important, right? We have to remember that we deal with this every day. So they say, oh, mom needs a power of attorney. Great, let's go do it. And mom doesn't even know who she is or what day it is.
Yeah.
Um, this is so important to get done prior to losing capacity to sign. Right.
Exactly, because once you do lose that capacity to sign, you can no longer do a power of attorney, and a guardian has to be appointed for you.
Not
And
even a
so it's
guardian.
really that's why it's crucial and critical that in your life, and you may not have to ever do it again, as Matt points out, it may not expire because if you become incapacitated after you've signed it with capacity, then it will last forever, literally. No one can force you to get a new power of attorney, especially if you can't. So it's really
Right.
important while you're capable, while you're competent, to create a good, solid power of attorney that's going to help you. Because there's nothing sadder than watching a person who has a situation that we can't help with because there's
Right.
no power to do it. And one last
Right.
thing I will say too,
Yeah.
about the choosing people and competency,
Oh,
it's
yes.
often very important when children bring or grandchildren bring their either parent or grandparents that you speak to the person alone, right? Because our
Yes.
client is the principal, right?
Yeah.
And we need to make sure that they agree that this is the person, that there's no duress, nobody's forcing them to do anything, or
Right.
that would really be doing our job, right?
Yes, I just had a woman come in and said, my mom needs power of attorney, and that's what you want, right, mom? You want me. And
Right.
the mother said, and her response was, well, whatever you want. And I said, well, that's not how it works. So let's start from the beginning.
Yeah,
Let's start
exactly.
this over. So, well, this is
Amazing
great.
stuff.
I think as a quick recap, power of attorney is so important. There's general durable power of attorneys for property rights. There's a power of attorney for healthcare, and both Andrew and I can help you navigate that topic. I can be reached at icanprotect.com. Andrew?
We are the Estate Planning and Elder Law Group. We can be reached at epelg.com. And just look us up on the web if you can't find if you don't remember that URL. We're located in Queens, New York, and Matt's located
Cleveland, Ohio. We are here to serve. So thank you so much, Andrew. It's always a pleasure talking to you.
up.
And I am so excited for our upcoming, what's our next topic?
Pleasure to
Our
talk to you too,
is-
Matt. And I'm really looking forward to be talking about wills,
Oh,
what a
excellent.
will is, and why where there's a will, there's no way out of court.
Ooh, I love that. Can't wait to hear that.
Instead of where there's a will, there's a way. Where there's a will, there's no way out of going to court. So we'll speak to you again soon. Thank you so
Thanks
much.
so much,
And
everybody.
just remember, try to evaluate us. Give us some information. Reach
Yes.
us at Matt's at info@icanprotect.com, and we're at info@epelg.com. And we always welcome comments. We want to know how we're doing. Please let us know. Thanks. And if you have any other topics you want us to do, please let us know about those too. Have a great
Thanks.
one, Matt. Take care.
Thank you. You too. Bye, everybody.
Bye.